Most.
Rapid, Your Lordship. Lordship, there is an item listed as item number 30, the stay matter. So I need, may I request Your Lordship that the matter may be taken up in an upgraded manner or immediately after the admissions are over here. Because a conditional stay has been granted for
You are
me to
for-
take justice service,
You are
which
for-
I have taken in.
Year four.
I have for the petition.
No one
There
has
is no one there in the respondent. Because I had been asked for to take a justice service for the conditional
Okay, okay.
stay
After,
to continue.
when
So
do
I
you
have
want
taken
it?
the.
When do you want? At what stage you want it?
I have taken it means
No, no.
it is there on the record. I have filed the affidavit.
You want upgradation to what stage?
No, after the admission part.
Okay.
That is my request here.
Maybe. Lordship, we do consent from the other side, Lordship, back to the item number 21. Here, Lordship, we are filing the objection to the stay petition today itself, Lordship. So matter will be taken up in the next week, Lordship.
You have informed other side.
Yes, sir, he is present, Lordship.
Matter 16th of August, 16th August.
Heard Mr. S.K. Dekar.
Yes, sir.
S. Dekar, learned counsel for the respondent who submits that the respondent will be filing
Today.
written objection today itself and therefore pays for listing this matter after some time. The Mr. S.K. Medhi, learned CGC consented to the prayer, hence the prayer is allowed. Let this matter be listed on
16th of August.
16th of August.
And there is the interim order.
The interim order shall continue till next day.
Public.
For listing of a transfer petition, civil lordship, Monday law.
Senior court. One more court is taking same roster. You have to mention before the senior court.
14 lordship.
Please, Lordship, I have to mention item number 6 of the release, my lord. But I'm saying this matter may be adjourned for the day, my lord. Due to some personal difficulty, my senior, my lord.
You have
That will be
informed the
correct,
other
yes.
side.
Huh, my
No.
lord?
None has appeared. Who is for the other respondent side? Nobody is
not yet.
appearing. What is your name?
V Vasco, my lord. No Vasco.
B.
Vasco.
B. Vasco, learned counsel for the appellant, prays for an adjournment on the ground of personal difficulty of the conducting counsel, Mr. B. Chetri. Considering the submissions, the prayer is allowed. Let this matter be listed after 2 weeks.
Declare.
Please, Lordship. Lordship, I beg to mention item number 23. Lordship, can you adjourn the matter for the day? As my senior is out of station,
Heard Mr.
as Afridi.
S. Afridi, who prays for an adjournment on the ground that his senior, who is the conducting counsel in this case, is out of station. Considering the ground mentioned by the counsel, the prayer is allowed. Let this matter be listed after 2 weeks.
Obliged.
My lord, in our interim order in my lord, IA, my lord, IA. That's IA interim.
In
21,
item number,
21, my lord.
in
Yes,
item
mention.
number 21,
In IA, my lord.
the interim order shall continue in the interlocutory application.
Yes.
Order of interlocutory application number they will have.
May please, Your Lordship.
And another thing, my lord, the lawyer court record is not come, my lord. That reminder may be given.
In item number
21, my lord.
21, issue reminder for the LCR.
May please, Your Lordship. I beg to mention item number 31 of the supplementary register. Lordship, may 31. Lordship, may allow me to wait the liberty to approach the first appeal court, Lordship.
31, what is the prayer?
Lordship, because of the change of pecuniary jurisdiction, I have to apply before the district judge.
You want to withdraw?
Yes, Lordship. So the liberty to oppose the first appeal court.
Okay. Heard Mr.
Our Borough.
Arbora, learned counsel for the applicant who prays for allowing the petitioner to withdraw the instant interlocutory application as he has approached the wrong forum. He also seek the liberty to approach the correct forum by filing appropriate petition there. The liberty is granted.
Lordship,
The-
may kindly make a direction if possible regarding the delay part. Lordship, to take
No,
care
no.
of it.
That you can argue before that.
Sure.
The With above observation, this application is dismissed on withdrawal.
Congratulations.
For are we Baki for last case this is. Okay. For reasons mentioned in the judgment, the impugned judgment is interfered with by altering the conviction of the appellant from section 6 of the POXO Act to section 10 of the POXO Act. And accordingly, the sentence is also modified from 10 years to 5 years rigorous imprisonment with a fine of rupees 1,000 and in default of payment of fine to undergo simple imprisonment for 3 months.
Wait, the lordship. Is a transfer petition, your lordship, seeking transfer from Guwahati to Gulaঘাট, your lordship. I am the wife, your lordship. The husband has filed a divorce petition, your lordship, before the Principal Judge Guwahati, Kamrup Metro, your lordship. Your lordship, the previous, prior to this divorce case, your lordship, the petitioner, that is the wife, has filed a domestic violence case at Gulaঘাট, your lordship, and the husband he appeared there, he contested there, your lordship, and after full trial, your lordship, final order was given, your lordship. But subsequent to this order, the husband has filed this divorce case, your lordship. And being a lady, your lordship, having 6-year-old child, your lordship, she's having
I heard
difficulty.
Miss S. Nazneen, learned counsel for the petitioner. This application under section 24 of the Code of Civil Procedure, 1908, has been filed by the petitioner, praying for transfer of which case FC within bracket civil case number 120/2024, which has been filed by the respondent, who is the husband of the petitioner, seeking divorce from the petitioner before the Court of Learned, Principal Judge, Family Court number 2, Kamrup Metro, to the Court of Learned District Judge, Golaghat. Issue notice to the respondent. The petitioner shall take steps for issuance of notice to the respondent by registered post with AD, as well as by usual mode within 3 days, within 7 days from the date of this order, returnable on 13th of September 2020.
Kindly matter be stayed, your lordship.
Learned counsel for the petitioner has also submitted that before filing of the instant divorce case, the present petitioner divorce case by the respondent at Guwahati, the present petitioner had filed a case under the Protection of Women from Domestic Violence Act in the court at Golaghat,
Yes, sir.
and the respondent had appeared there and contested the case. She therefore prays that contested the case stop. In view of above, till returnable date, further proceeding of the FC civil case number 120/2024 be kept in shall be stayed list accordingly.
Deeply obliged, your lordship. 3.
May it pleasure your lordship. Lordship, here I am appearing as a legal aid counsel, lordship. Against the judgment and order dated 26/2/2024 passed by the learned additional district judge, lordship, whereby the matrimonial appeal filed by the title suit divorce filed by the respondent is decreed in his favor, lordship.
Decree of divorce was granted.
Yes, lordship. Resolving the marriage, lordship. In fact, lordship, the two main issues, desertion is issue number 2 is decided in negative and issue number 1 is decided in favor. Desertion is decided against the husband, lordship, and the cruelty is decided in his favor. But here, lordship, the petitioner,
Is there any delay in filing these? Delays there?
here, lordship, it's not delayed. There is no delay. 90 days is there, but the certified copy I have received some time, and within that time I have filed this.
Heard Miss B. Sharma, learned counsel for the appellant, learned counsel for the petitioner. This civil revision petition has been filed.
She is all willing to continue her conjugal life. She had also stated that in
You
her
have
written statement.
mentioned wrong provision. This is under 226 or 115.
Lordship, I stated it as 227, then they corrected it, office corrected it as 111. That office corrected it.
Then it has to be 115 of the CPC.
Lordship,
It
I
is 11.
written it as article 227 of constitution, but office corrected it.
How office can correct?
In my copy, still it is 227 of constitution of India, but office corrected it as 115. That is what is their first page also, they have defect. They have stated that is the defect, and that is why it has to be corrected.
Okay, we'll see this issue. You don't mention this section. What has been dictated? Filed by the petitioner. Petitioner Srimati Ankita Datta, impugning the judgment dated 26/2/2024, passed by learned additional district judge within bracket FTC, Dibrugarh, entitled suit within bracket D, number 7/2022, whereby the marriage between the petitioner and the respondent was dissolved by a decree of divorce. Issue notice to the respondent. The petitioner shall take steps for issuance of notice to the respondent by usual mode as well as by registered post with AD within 3 days. Within how many days?
By Monday, I will take.
Within 3 days from the date of this order, returnable on 18th of September. List accordingly.
Lordship, there is a stay, prayer for stay also, Lordship, because that is the only,
Stay we will consider after service of.
in the meantime, Lordship, if he,
No, it is only decree of divorce.
yes, Lordship,
What will happen?
he may remarry, Lordship.
No, let the notices be served.
Till the returnable, that Lordship, if in the meantime he marries, then it will,
No, the prayer for, you take steps for issuance of notice. Interim we will consider on the, after the prayer for interim relief would be considered after due service of notice on the respondent.
May it please your lordship. And it's a regular statutory appeal
in a probate case, my lord. Petitioner, appellant and respondent, their brothers, my lord. In respect of one brother, my lord, will was probated, my lord. And against this, my lord, order passed by the honorable Learned District Session District Judge, my lord, I have referred this appeal. And your lordship kindly see the executor, my lord, who has done the will, my lord, my father, he was an 88-year-old man suffering from dementia, my lord. And he is a school teacher. The
Okay,
will,
in main appeal, we are issuing notice.
and regarding, my lord, I stay or I
Stay will hear you.
My
Let
lord.
me- Heard Mr. T.J. Mohanta, learned senior counsel assisted by Miss P. Bhattacharya, learned counsel for the appellant. This appeal under section 299 of the Indian Succession Act 1925 has been filed by the appellant impugning the judgment and order dated 31/5/2024 passed by learned District Judge Jorhat in title suit / within bracket probate case number 1/2016. Whereby, what was the outcome of the title suit? The probate was allowed.
probate was allowed.
Probate was
In respect of respondent number 1 and 2, my lord.
granted in respect of probate was granted to the respondent number 1 and 2 in respect of the will of the deceased. Who was the deceased? Your
My father, Dr. Dharbara.
who is the father, who was the father of the present appellant? Stop. Issue notice to the respondents. The appellant shall take steps for issuance of notice to the respondents by registered post with AD as well as by usual mode within 3 days from the date of this order, returnable on returnable on 10th of September 2024.
My lord.
Yes, what is your preference?
Regarding my lord, say, my lord, your lordship kindly see, if in the meantime, my lord, the certificate is issued, my lord, everything will become in touch first. And here, my lord, actually, I don't know, my lord, why DW2, who was the family doctor, his evidence was discarded. Number 1. Number 2, my lord, my father is a school teacher. How he'll put a thumb impression in, my lord, the will, my lord. Your lordship, that is another aspect. Another point is that, my lord, that one of the attesting witness says will was drafted in, my lord, English by one advocate. But will which was executed, my lord, in question, my lord, that was in Assamese, and it is drafted in by a Mohori, my lord. That may Toroni, my lord. So this aspect were totally overlooked by the learned court below, my lord. So your lordship kindly see one aspect, my lord, evidence, my lord, that will be, everything will be clear. In fact, my lord, this document was registered, but from the person who is from registered office, he himself said that, my lord, the executant did not sign sign in the will, my lord. Page 57, my lord. Page 57, kindly see, my lord. He is the official witness, my lord. 88-year-old man, my lord, just before his death, my lord, 2 months ago, he's suffering from Parkinson. Doctor says, my lord, when he came to the office, my lord, of the sub-register and put his signature, my lord, thumb impression, my lord. Page 57, my lord, kindly see, my lord. At the time of execution, has your lordship got it, page 57, my lord? It's the first part of the official witness, my lord. At the time of execution of the will, the executant has to write his full name. In the content of the will, name of the execution was written as a Dandodhar Bora. It is a fact that executant Dandodhar Bora has not put his signature in the will. As his name in the reflected in the content of the will, he has put his signature with 2 alias name, but no document has been attested here with so that there is one and same person. and no explanation has also given in the aforesaid will executed by the executant. In the event of admissibility of the name of the executant mentioned in the will and the signature, the sub-registrar, joint registrar, and Jorhat has to give his explanation. In the instant will, no such explanation is given by the sub-registrar in Jorhat. So even then, my lord, it was taken into account, and now, my lord, another last para of that evidence, my lord. It will be the photograph of the in the will. The photograph of the attesting witness was not affixed. The biometrics of the photograph of the attesting witness were not affixed. The passport size photograph were not present in the will. So these are the discrepancy that, my lord, the official witness, my lord, himself came to the court and says, now, my lord, your lordship, will I have a photocopy of the will I have annexed, my lord? Now, your lordship, one of the attesting witness, my lord, that is PW, my lord, 4, page 35, my lord, page 51, my lord.
Yes.
Page 51 is the, my lord, evidence of the one of the attesting witness, my lord. 11 portion in cost, my lord, your lordship, kindly see page 54, my lord. Page 54, my lord. Will was drafted as sub-registry office, Jorhat. One advocate drafted the aforesaid will. The will was prepared and drafted in English by a English language. I have not seen the draft copy of the will in the court today. So he says, my lord, it was drafted in English, and your lordship, kindly see the will now.
Now, whether his testimony was relied by
My
the
lord,
state.
these are the document, my lord, their testimony, my lord, they're relying on that, my lord. And these are the testimony they relied, my lord, and DW2, my lord, who has clearly stated that since 2012, he's suffering from Parkinson, dementia, and that evidence is totally overlooked, my lord. So my submission before it's a fit case.
Dementia or Parkinson's?
Dementia, my lord. Your lordship, kindly see evidence of DW2, my lord. DW, he is a family doctor, my lord. Page 67, my lord. Page 67, my lord. Page 67, my lord. Dr. Pradeep Kumar Medhi. Page 67, has your lordship got it?
Yes,
Right.
yes.
That I received a summon from the court, this court. I was serving as a senior medical and health officer in KK Civil Hospital, Golakar, 1999 and 2012.
Okay,
During the last period, I also served.
okay, okay.
My lord.
Now, what will happen if it is not stayed till the period of notice?
Your lordship, kindly see page 96, my lord. Page 96. Page 96. Page 96, my lord. Para 37. 36, I mean. 37, my lord. After receipt of the valuation report from the concerned circle officers, Jorhat issue probate certificate to the name of the petitioner, namely Sri Krishna Kanta Bora and Srimati Lakshmi Bora, for said probate and submission of the same. So if they will issue the probate certificate, my lord, it will become infraction. And normally, my lord, when
No, I just want to understand.
my lord,
Suppose probate certificate is issued
my lord,
and ultimately in this appeal it is found that the impugned judgment is
wrong.
wrong. Then what will happen? Then certificate will be cancelled.
Definitely certificate will go, but by virtue of certificate, they can do other things, my lord. It will multiplicity of the case, my lord. They will transfer the land in his name, and more so, my lord, very important point that was not discussed. These are the ancestral property. This is not the property of my father only. That aspect also not, but that I'll come to later on when the time of hearing.
Mr. T.J. Mohanto, learned senior counsel assisted by Ms. P. Bhattacharya, learned counsel for the applicant. This application under Order 41, Rule 5 of the Code of Civil Procedure, 1908, has been filed by the applicant for stay of execution of judgment and order dated 31/5/2024 passed in title suit probate case. Title suit within bracket probate case number 1 of 2006 by the London District Judge Jorhat. Learned Senior Counsel for the applicant has submitted that the applicant has filed the connected testamentary appeal number 6/2024 impugning the aforesaid judgment. Stop. Learned Counsel for the applicant has also submitted that in the impugned judgment, the trial court has not taken into consideration the
PWs and DWs are in true and proper prospect, my lord.
the testimony of prosecution, the witnesses of plaintiff side in its true and proper perspective. It has ignored the fact that DW2 has deposed that DW4 has deposed. Who is the doctor?
DW2, my lord, Doctor P.K. Medhi, my lord.
At which page?
Page 67. Dr. Pradeep Kumar Medhi
Has deposed.
is suffering from dementia since 2012. Clearly in sheet, my lord, he is stated.
When the will was executed,
2014. And dementia is a disease, my lord, it cannot be cured, my lord.
that the testator late Dandadhar Bora was treated by him in the year 2013 when he was suffering from senile dementia
Since 2012.
and hypothyroidism since 2012. Learned Senior Counsel has also submitted that the court also did not took into consideration that one of the witnesses, namely, who said that it is in English?
My lord, PW4. Page 51, PW4, my lord.
PW4
My lord.
has deposed during cross-examination that
He is one of the attesting witness, my lord.
PW4 who is one of the attesting witness of the will has deposed that will was prepared and drafted in English language, whereas in fact the will has been drafted in vernacular Assamese language.
That is not even examined.
Stop. Issue notice to the respondents. The applicant shall take steps for issuance of notice on to the respondents by registered post with heading as well as by usual mode returnable on. What was the date given in the returnable on 10th of September 2024. However, considering the submissions made by Learned Senior Counsel for the applicant as discussed herein above, the operation of impugned judgment dated 31/5/2024 shall remain stayed till the next returnable date,
My lord, deeply observed.
list accordingly.
So far as my appeal is concerned, appeal is admitted, my lord.
Yes,
Appeal is
in
admitted,
appeal,
may be called.
appeal is admitted. Let the record in main appeal, let the record of title suit probate case number 1/2016 be called for from the trial court.
DPW.
My lord, present appellant claimant, my lord, he is injured, my lord. He met an road accident and for which he sustained previous injury with bone fracture. My lord, he filed a MSc case before learned tribunal. And my lord, he exhibited, my lord, certified copy of FIR, charge sheet, GD&T,
Your claim was dismissed?
dismissed, my lord.
Okay.
My humble submission, my lord. Only one submission, my lord. Certified copy need not to be proved since it is a public document. My lord, even then, my lord, matter may be remanded back, my lord. I will prove those. sir.
No, let us first admit the appeal.
But my submission, my lord,
No, how, without admitting the
My lord,
appeal,
my lord,
without
obvious,
issuing the
my
notice,
my lord,
heard Mr.
A Manna,
Heard Mr.
A Manna.
A. Manna, learned counsel for the appellant. This appeal under section 173 of the MV Act, 1988 has been filed by the appellant, impugning the judgment and order dated 30/4/2024 passed by learned member, Motor Accident Claims Tribunal, Amingao, in MAC case number 82/2024, whereby the claim case was dismissed So issue notice to the respondents. The appellant shall take steps for issuance of notice to the respondents by registered post with AD as well as by usual mode within 3 days from the date of this order, returnable on 20 September 2024. List accordingly.
My lord, small fair, my lord. Here in this case, my lord, 5,000 rupees, my lord,
Cost.
has been cost. My lord, that may be state, my lord. If the poor person, he lost his case and another 5,000 should be paid. My lord, that may be. still
No,
done.
after service of notice on the respondents. Let
In the
respondent.
meantime, my lord, execution will be proceeded, my lord. Otherwise, I will
No,
in trouble. my
If,
lord.
if execution for what?
My lord, I am, learned tribunal has directed, case, my lord, 22.
To
Directed
pay the cost.
cost, my lord, to be paid to the district legal service within.
You pay the cost, there must be some reasons. Or you wait till you have filed a frivolous MSc case. That was the ground.
No, my lord. My lord, everything I have certified, so I have it. You lordship kindly, one observation you lordship kindly see. Furthermore, the claimant side has failed to prove the GD&T, FIR, charge sheet as per law. This is the observation. Another observation, my lord. During cross-examination, the claimant PW1 admitted that he has not proved Form 54, that is.
You make a prayer for that. Okay, till returnable date. The cost till returnable date, the impugned judgment regarding the imposition of costs of rupees 5,000 on the appellant shall remain stayed.
Oh, bless me. I love this.
Yeah, please, your lordship. This is an appeal under section 173(1) of the MV Act for
Enhancement.
enhancement of the quantum of compensation. My lord.
Heard Mr. B.K. Jain, learned counsel for the appellant. This appeal under section 173 within bracket 1 of the MV Act, 1988 has been filed by the appellants praying for enhancement of the award which was granted to the appellants by the impugned judgment and order dated 26/2/2024 in MAC case number 1848/2018 by the Motor Accident Claims Tribunal number 1, Kamrup Metro. Issue notice to the respondents. The appellants shall take steps for issuance of notice to the respondents by registered post with AD as well as by usual mode within 3 days from the date of this order, returnable on 19th of September 2020. Thank you.
May it please your lordship. My lord, this is an appeal filed with the insurance company lordship, mainly on the ground that the vehicle had no permit at the time of accident lordship, which is a violation of terms and conditions of the policy lordship. Your lordship, it is admitted by the owner and driver by filing written statement that one permit was submitted, but that was not valid at the time of accident. That is, accident took place
Okay.
on lordship.
Heard Mr. M. Chaudhary, learned counsel for the appellant. This appeal under section 173 of the MV Act 1988 has been filed by the appellant insurance company impugning the judgment and order dated 2/5/2024 passed by learned member, Motor Accident Claims Tribunal number 3, Kamrup Metro in MAC case number 290/2019. Issue notice to the respondents. The appellant shall take steps for issuance of notice to the respondents by registered post with AD as well as by usual mode within 7 days from the date of this order. The notices are returnable on 20th of September 2020.
Lordship, the steps can be 1 to 5, all are sons and daughters of the claimant number 1, lordship. 1 to 5, can I take 1 steps, lordship?
Mhm.
Residents of same
You have to issue notice to all.
lordship. And I have a petition for stay, lordship. 2283 of 24,
Deposit 50%.
lordship.
Ms. M. Chaudhary, learned counsel for the applicant. This interlocutory application has been filed by the applicant for stay of the execution of the judgment and award dated 2/5/2024 passed by the Motor Accident Claims Tribunal number 3, Kamrup Metro in MAC case number 290/2019, whereby an award of rupees, how much?
10,53,684. Lordship will find is at page, lordship 20,
Award of rupees
27.
10,53,684
684.
along with an interest of 9% per annum from the date of filing of the claim petition till realization. The applicant has filed the connected MAC appeal number 382/2024 impugning the aforesaid judgment and award on the ground that the vehicle involved in the accident was flying on the road at the time of accident without permit, and therefore there was violation of the terms and conditions of the insurance policy, and hence the applicant slash appellant is not liable to pay any compensation. Stop. So I have considered the submissions made by learned counsel for the applicant. Whether to issue notice or not.
Lordship may admit the appeal, Lordship.
No, appeal will be admitted in I.
Lordship, I pray for total stay, Lordship, without payment, Lordship.
No, then we have
If
to,
then Lordship may not allow to withdraw, Lordship. Let them appear and they will file, then we'll.
no,
operate,
then let us issue notice first. Let
On
them,
stay.
on stay, let them appear. Issue notice, if you are,
Lordship.
issue notice to the opposite parties. The applicant shall take steps for issuance of notice to the opposite parties by registered post with AD as well as by usual mode within 3 days from the date of this order, within a week from the date of this order, returnable on 20th of September, list accordingly.
Must apply.
Yeah, please, your lordship. Lordship, your lordship may kindly peruse the order dated 26/6/24, your lordship, passed by this honorable court. By this order, your lordship, in para 6 and 7, I had the justice service was directed to be effected within 26/7/24, and the interim order was extended till today, subject to me completing the justice. Now, the justice service has been completed by me and an affidavit to that effect has been filed, your lordship. We completed the justice on 12/7/24, your lordship. And an affidavit to that effect has already been filed before this honorable court. It is in, your lordship will find an additional affidavit has been filed, your lordship. So in pursuance to this order, the compliance have been made, your lordship.
Wherein you have filed affidavit.
Yes, your lordship may get it on page 69, I think. It is a serially, it has given, the additional affidavit should be there, your lordship. It starts from page 69. And
Where is the additional affidavit? So the
additional affidavit,
additional affidavits. Because in this file, the last page is 68.
no, I think it would be additional affidavit I filed. It was filed, your lordship.
It is not on record.
On 16 July, it was filed.
It is not yet filed,
I have filed it, it is there, your lordship.
not on record.
I have to check then for the registry.
Okay, we are listing it again after a week.
It is not in the list.
Heard Mr.
A Biswas.
A. Bishwas,
Can it be
learned-
fixed on Monday, your lordship?
heard Mr. A. Bishwas, learned counsel for the Tuesday. Learned counsel for the petitioner who submits that in pursuant to the order dated 26/6/2024, the petitioner has taken steps for
Justice service.
effecting the service on the, how many respondents are there?
Respondent number 1 to 5, your lordship.
All, on all Dusty service first,
They are the
on-
brothers
on-
of the
on- on
petitioner.
the
and
respondents.
brothers and sisters.
through Dusty mode. And in pursuant to, and in compliance of that, the petitioner has also filed an affidavit of compliance. Stuff. However, on perusal of the case record, it appears that the affidavit, which is stated to be filed by the petitioner on 16
July. your lordship.
16 July 2024 is not available on record. The registry is directed to place the affidavit filed by the petitioner on record and list this matter again on on 6th of August 2024. The interim
May be continued, your lordship.
order shall continue till next day.
Highly obliged.
May I please, Lordship? Lordship, I would like to withdraw that.
Withdraw.
Yes.
Why?
The evidence is closed, it's fixed for SD.
Okay, okay. Heard Mr. M. Rahman, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant bail application. Also heard Mr. K. Busher, learned additional public prosecutor. Considering the submissions made by learned counsel, the prayer is allowed. This bail application is dismissed on withdrawal.
Highly ob-
Actually, in this matter, CD not received, lordship. The interim was there. Lordship, here another matter is also tagged, not tagged, but there is the same from the arising out of the same FIR. That is also annexed, lordship. That was fixed on 8/8/2024, lordship. But by the coordinate bench, but when the interim was granted by your lordship itself. Maybe fixed together or any other date, lords.
Heard Mr. S. Kashyap, learned counsel for the petitioner. Also heard Mr. K. Busher, learned additional public prosecutor, who submits that the case diary is not available and seeks some more time for production of the case diary. The prayer is allowed. Let this matter be listed again on 8th of,
Because another matter is also fixed on 8th, lordship.
okay.
But it is in the
So
coordinate bench.
we'll fix it after 8.
After 8th, lordship. The 9th, lordship.
Let this matter be listed again on 9th of August,
Yes, lordship.
2024.
This is an appeal.
Yes,
Well, very peculiar in this case, my lord, I found that the plaintiff filed a suit and she executed a sale deed in favor of the appellant, present appellant, in the year of 2000.
what suit was filed?
Suit for declaring right title interest in the corporation.
Okay.
Then, my lord, that deed was executed by her in 2000 by registered deed. She went to the office
In
and
favor of,
2000,
in favor of whom?
my appellant.
Okay,
In for appellant. But they, when the file, suit file, this is exhibit B is the said sale deed, but she is not claim for cancellation of the said deed, madam. Whether it is fraudulently obtained And no issue has also been framed in this regards. But the learned Munship has decreed the suit. And also counterclaim my, this counterclaim, only that I am failed to prove it. But admitted fact, my lord, she is executed it in my favor. And after 12 years, she filed a suit that I am not executed that.
Was it a registered sale deed?
Register sale deed. Register sale deed, ma'am. Number one. Number one, London Munship, my lord, as well as the appellate court, very interestingly, my lord. Another suit was filed by one Abul Kalam against the appellants. That suit was decreed in favor of the appellant. Very interesting, my lord. On the aid of that, Lordship Kalisi, ground number B, my lord.
No. You first tell me the facts clearly.
Hello.
You were the defendant in
Yeah, I am the defendant of the
suit was filed by
by
the
present respondent.
respondent. What was the relief?
Relief suit was decreed.
No, relief sought was declaration of right title and interest.
Interest. That one, but there is no declaration for cancellation of the deed executed by her. That was one. Plain is there. I like the plain.
Possession was with,
Am I right?
in whose possession this suit land was?
Man, I am now possessing my lord.
You are possessing.
Yes, my lord.
So,
After passing, I am
no,
possessing,
listen
my
to
lord.
me first. So whether the prayer for recovery of possession was there,
Your Lordship Kalisi, page 43.
whether you answer my
Yes,
queries,
yes.
whether the, have you gone through the memo of appeal properly?
Yes, my lord.
Then you answer my queries.
Recovery is not there, my lord. Declaration of like title and interest of the plaintiff of the suit land and for partition of the suit land.
For partition.
Yes, and for partition.
Okay.
Right title, interest and partition.
Okay.
Page 43 is the plaintiff, my lord. Your Lordship Kalisi.
What is your name?
My name is Anwar Hussain.
The appellant.
Anwar Hussain.
Anwar Hussain.
Yes,
You were the defendant number one.
One. And other defendants are not.
This was in respect of which land?
In respect of land measure 1 katha, my lord. 1 bigha, my lord. Schedule
Schedule land is
Yeah,
4
my lord.
bighas.
4 bighas, elements are so and so. Bighas so and so, dag number so and so, and so and so. After partition of the so and so, the degree is so and so. In the execution or title execution case number 3 remains 2 bighas of land so and so. In dag number 1. 1 bigha, my lord. Last, my lord. Let us. In dag nong 575, 1 bigha 0 katas land dag number so and so. That 1 bigha is in the some me, my lord. I passes that 1 bigha, my lord, from the plaintiff.
Now, suit land was 4 bighas, 3 kathas, 11 lecha.
Yes, ma'am. But my part is only for 1 bigha, I passes, my lord. That is why I have been made respondent number 1, defendant number 1.
Out of these 4 bighas, 3 kathas, 1 lecha.
I am concerned only for 1 bigha. I mentioned in my counterclaim, my lord.
You filed a counterclaim.
Yes, my lord.
Then what happened? Your counterclaim was
Counterclaim also dismissed.
dismissed and
Only-
suit
only-
was decreed.
Suit was decreed.
Where is the judgment of the trial court?
Trial court judgment is, my lord. Page 24.
There is recovery of possession also.
Yes.
By,
In order, it has been recovery position also.
so
In
you are,
order. But in plain it is not mentioned. On the right title interest and partition.
Okay. Then you preferred an appeal.
It was
What was the finding in the appellate court?
appellate court upheld the finding of the
Where is the appellate?
that and my lord says six is the appeal.
Yes.
Case 14, my lord, also no issue has been framed for cancellation of the sale deed. She did not get take any relief. Whether the deed has been fraudulently obtained or not.
Whether you took that plea before the trial court,
That point.
that
Yes, that point I found in Lordship kindly see is onward from page 7. Page 8. Further, the learned trial court has pronounced judgment which is not framed as issue in the suit.
page number?
Page 8, para 6. Further, the learned trial court has pronounced judgment which is not framed as issue in the suit has come to the wrong decision. That issue is, my lord, they should get a say the relief that the suit has been fraudulent, the deed has been fraudulently obtained. That issue was not framed. And moreover, my lord, whether one judgment has been pronounced and both held that I have the habit, I have the habit to take over land of other person, I have the habit, I have a history. Can that be a ground for declaring the suit, my lord?
Now, what substantial issue
You
are
here I
proposing?
mentioned page 3, my lord.
Which one? First one is not a substantial issue.
Now the second B you loss of kindly say. Whether the plaintiff respondent admitted in her evidence that she duly executed registered sale
This is
deed
a question of fact.
my lord.
This
No,
is a,
here come, latter part come, my lord. In favor of the appellant defendant 1 and no relief was sought for cancellation of the said deed in the plain and no issue in this regard has also been framed as to whether the defendant number 1 obtained exhibit B fraudulently. And as such, whether both the court bill was justified in holding that the appellant defendant number 1 fraudulently obtained the registered seal deed exhibit B, rendering the same level to be cancelled. Number 2, whether would the court bill rightly held that held at the aid of the judgment passed in so exhibit 2, which was filed by one Abul Kalam against the appellant that the applicant dependent number one has a history of possessing the land of others, and that act of the dependent number one, applicant number so and so.
That
yes,
is factual question.
my lord. Then D also B. Then my lord, D. The judgment and decrees passed by both the courts below suffers from perversity.
What is the perversity?
Perversity is there, my lord, because my evidence has not been considered. She admitted that yes, she has executed the deed, but now after 12 years, she filed a suit that I am not executed that any registered deed, my lord. Complete perversity is there, my lord. Now, E also, we're finding an decision arrived by the appellate court below holding that since exhibit B has obtained fraudulently, declaring the title of the plaintiff of the suit land is visited by perversity on complete non.
In whose possession that 1 bigger land is?
One bigger land.
Is it in your possession?
In my own, my, she told me, and in my.
Whether any execution case has been filed?
No,
Not yet.
not yet.
Heard
After-
Mr. J. Ahmed, learned counsel for the appellant. This regular second appeal under section 100 of the Code of Civil Procedure has been filed by the appellant, impugning the judgment and decree dated 22/3/2024 and 1/4/2024 respectively by the Court of Learned Civil Judge Borpeta in title appeal number 41/2024, whereby it upheld the judgment and decree passed by Learned Munsif number 1 Borpeta on 27/4/2022 in title suit number 80/2014, whereby the suit of the respondent was decreed and the counterclaim filed by the present appellant was dismissed. After hearing learned counsel for the appellant and after perusing the memo of appeal as well as the documents annexed along with the documents annexed with the memo of appeal, following substantial question of law is formulated. Whether the trial court as well as first appellate court were right in dismissing the counterclaim of the appellant and decreeing the suit of the defendant, respondent.
Plaintiff respond.
Respondent/plaintiff, when no relief was sought for cancellation of registered sale deed number 1328 dated 5/5/2000, which the 5/5/2000 and whether the above mentioned courts were correct in holding the said sale deed to have been fraudulently obtained without framing an issue to that effect. Stop. Question mark. Issue notice to the respondents. The plaintiff, only one respondent,
Still one respond.
issue notice to the respondent. The appellant shall take steps for issuance of notice to the respondent by registered post with ID, as well as by usual mode within 3 days from the date of this order, returnable on 13th of September 2024,
Within 7 days, I will take.
within 7 days.
My lord, others, I will maybe permitted to commit other substitution question at the time of hearing.
That law is there. If,
It can be permitted.
if I'm not mentioning it,
My lord,
I'm not mentioning it in this
my
record.
lord, IA is there.
We are issuing notice as
Correct.
no execution case has yet been filed.
Yes. But,
No, you have yourself stated.
yes, and I, no, it will not.
This heard Mr. J. Ahmed Leonard, counsel for the applicant. This application under Order 41 Rule 5 of the Code of Civil Procedure has been filed by the applicant, who has filed the connected regular second appeal number 141/2024, praying for staying the execution of the impugned judgment and decree dated 22/3/2024 and 1/4/2024 respectively, passed by learned Civil Judge Borpeta in title appeal number 41/2022, whereby it upheld the judgment and decree dated 27/4/2022, passed by learned Munsif number 1 Borpeta in title suit number 80/2024. Issue notice to the respondent / opposite party. The applicant shall take steps for issuance of notice to the respondent / opposite party within 7 days from the date of this order, returnable on 13th September.
Well, in the meantime, my lord, status, if they, in the meantime, they can be filed.
If you come,
Wait, but the second appeal by the defendants against a decree of reversal. Declaratory suit was filed by,
or reversal,
well, declaratory suit was filed by the plaintiffs, seeking, my lord, a decree of declaration that they are entitled to inherit the suit land, that they are in possession of the suit land, and that the defendants are to be restrained to encroach upon the land. Pursuant thereto, my lord, the learned trial court, after
no,
taking into
decree was for declaration and
declaration and injunction
Injunction.
and confirmation of possession. The declaratory suit was basically, my lord, for a declaration that the plaintiffs are entitled to inherit the suit land, being the class 2 legal heirs of deceased so and so, whose successors, in fact, successors were the defendants, made defendants in the suit. Now, the factual, the factum of the case, my lord, was that the plaintiffs on earlier occasion had filed one suit, and that suit was eventually decreed
plaintiff
on
means
compromise.
present appellant. Present appellant
By present appellants, the appellants before your lordships are the defendants.
in the main suit.
They are the defendants in the main suit.
Okay.
Now, the plaintiffs in the suit had previously filed another suit that was against the predecessor in interest of the defendants of the subsequent suit. And that suit was eventually decreed on compromise, wherein the plaintiffs had relinquished their rights over the suit land scheduled in that particular suit. Now, after having relinquished the right in favor of the predecessor in interest of the defendants in the present subsequent suit, who are the appellants now before your lordship. Now, down the line, they have again filed this suit involving the same suit land. And here they claim that they are entitled to inherit that land after the demise of the predecessor in interest of the defendants. Now, to that, there has been an adjudication by the learned trial court eventually dismissing their claim, their suit, where your lordship will kindly see it starts from the judgment of the learned trial court starts from page 32. I'll take your lordship to the relevant part of the judgment, that is the adjudication in respect of, there were 3 issues framed, my lord, if your lordship kindly sees. If your lordship takes up the issues at page number 39 for a while.
Just a minute.
Page number 39, your lordship has got.
Yes.
Now, your lordship will kindly see the pertinent issue was the issue number 3, whether the plaintiffs are entitled to inherit the properties of Bhadra Gogoi Gohain being class 2 heirs. Now, to that, my lord, the adjudication is at page 42. If I may take your lordship to page 42 in regard to the adjudication of issue number 3. My lord has got page 42.
Yes.
May I read the issue number 3 now?
Yes.
Whether the plaintiffs are entitled to inherit the properties of Bhadra Gogoi Gohain being class 2 heirs. PW1 and PW2 along with their deceased brother Prema Gohain were the lawful owners of Bhulanath Gohain alias Bhulanath Bora of the Schedule B land. After the death of their father, they inherited their share of land. PW1 sold 4 kathas 10 lechas of his share of the inherited land to pro forma defendant number 5. Exhibit 1 is the certified copy of the Jamabandi of PP number 362 of Godhuli Bazar, Moza, so and so, showing the names of both the plaintiffs. The deceased brother of the plaintiffs, Prema Gohain, lived with one Bhadra Gogoi Gohain as his concubine, and no social marriage had taken place between the parties. But after the death of Prema Gohain, managed to get her name mutated in place of Prema Gohain in respect of her brother's share of land without their knowledge, and had also applied for partition. When the plaintiffs received notice from the circle office, Amguri, as regards to the partition case, the plaintiff filed a civil suit against Bhadra Gogoi Gohain for declaration, cancellation of the aforesaid mutation and permanent injunction in title suit number 17 of 2003. Both the parties compromised the matter and a compromise decree was drawn. As per the compromise decree, the plaintiffs waived their right, title, and interest over Schedule A land, which is the suit land, in favor of Bhadra Gogoi Gohain, who became the lawful owner of the suit land. Exhibit 2 is the certified copy of the decree passed in title suit 17 of 2003. The plaintiffs have been occupying and possessing the Schedule B land by cultivating paddy and paying land revenue. Exhibit 3 is the up-to-date land revenue paying receipt in respect of PP number 362 of Godhuli Bazar, Moda. PW1 deposed that the defendants, who are brother and nephews of Bhadra Gogoi Gohain, have filed a proceeding under section 145 CRPC and have been attempting to grab the suit land. Exhibit 4 is the copy of the petition under section 145 CRPC, and Exhibit 5 is the copy of order of additional district magistrate Sibsagar as passed in his case number 22 of 2018. PW2, one of the co-plaintiff, corroborated the entire facts deposed by PW1 in his evidence on affidavit. Both PW3 and PW4 deposed that the plaintiffs, along with Prema Gohain, are the 3 sons of Bhulanath Gogoi, who was known as Bhulanath Bora during his lifetime. They both deposed that no social marriage took place between Bhadra Gogoi Gohain and Prema Gohain, and she stayed as a concubine. PW3 and PW4 also deposed that Bhadra Gogoi Gohain died in the year 2018 without having any issue of her home. Further, the plaintiffs have been occupying and possessing the entire land of late Bhulanath Gohain by cultivating rice crop annually till date. As the defendants failed to cross-examine the PWs, the evidences of the plaintiff side remain unrebutted and unchallenged. The plaintiffs in their plaint, as well as in their evidences on affidavits, as well as PW3 and PW4, have clearly stated that no social marriage took place between Bhadra Gogoi Gohain and Prema Gohain, and she stayed as a concubine and without any issue of her own. Further, the plaintiffs have waived their right, title, and interest over Schedule A land, which is the suit land of the instant suit, in favor of
Now,
Bhadra Gogoi
who are
Gohain.
the plaintiffs? They are, what is their relationship between Bhadra Gogoi and Prema Gohain?
My lord, the plaintiffs are the 2 brothers of Prema Gohain.
Okay,
Gohain.
therefore class 2 years.
That's why they claim to be class 2 years.
Okay.
May I read further? Further, the plaintiffs have waived their right, title, and interest over Schedule A land, which is the suit land of the instant suit, in favor of Bhadra Gogoi Gohain by way of a compromise decree in title suit number 17 of 2003. The plaintiffs have filed the instant suit for a declaration as class 2 heirs of Bhadra Gogoi Gohain. At this juncture, it would be pertinent to mention section 15, 16, and Schedule B of the Hindu Succession Act 1956. Section 15, general rules of succession in case of female Hindus. Thereafter, my lord, appreciation of the statutory provision of section 15 and section 16 in the next 3 pages till page 47. Now, after my lord, the appreciation of the relevant statutory provisions, if your lordship kindly takes up page 48, here the conclusion has been drawn by the learned trial court at page 48, my lord, if your lordship
Yes,
kindly
read,
takes up.
read.
Bhadra Gogoi Gohai died unmarried and without any issue of her own. And further, the plaintiffs had renounced their right over the suit land, that is Schedule A land, by a compromise decree in title suit number 17 of 2003, Exhibit 2. As such, the property shall devolve upon her brother and to her brother's sons, who are the class 2 heirs of Bhadra Gogoi Gohain as applicable to females who have died intestate under the provisions of the Hindu Succession Act 1956. As such, the plaintiffs are not entitled to inherit the properties of Bhadra Gogoi Gohain as class 2 heirs. The issue is decided in negative and against the plaintiffs. Now, this was the core issue which was decided.
What is your relationship with Bhadra Gogoi Gohai?
The defendants who have been arraigned in the suit, one of the defendants is the brother, and the other defendants are the nephews of Bhadra Gogoi Gohai. And the allegation was that we have been resorting to activities which has clouded the right and title of the plaintiffs over the portion of land which they admit to have been relinquished in the previous suit. And now they are claiming to inherit as class 2 legal heirs. Now, your lordship will see, after the passing of the judgment and decree in the trial court dismissing the suit, they preferred appeal before the first appellate court. And the learned first appellate court.
No. One query.
Well,
Who is Ratneshwar Gogoi?
Ratneshwar Gogoi is the brother of Bhadra Gogoi Gohai,
Rupam Gogoi?
the son of Ratneshwar Gogoi, the nephews.
Okay. And who is Biren Gohai?
Biren Go, my lord,
Biren and Horkanto Gohai?
Biren Gohai and Horokanto Gohai are the siblings of Prema Gohai. Prema Gohai
Is
was
the
living with
husband of the,
my lord, they have themselves in their plain stated that
Okay.
there was no social marriage that had ever taken place.
okay.
Right.
Now, what appellate court
Yes.
held?
Now, your lordship will kindly
Their
see,
suit was dismissed.
the suit was dismissed. Against that, they preferred appeal under order 41. Now, against, in the appeal, my lord, your lordship will kindly see the adjudication that has the appellate judgment starts from page 72. I'll take your lordship to the relevant part of the appellate judgment from
Now,
page
what
85.
what it held while reversing the,
Now, here, my lord, may I just read the relevant part at page 86, my lord.
yes.
Page 86, madam. Now, in regard to issue number 3, whether the plaintiffs are entitled to inherit the properties of Bhadra Gogoi Gohai
Where are
being
you
class 2
reading?
legal heirs.
Page 86.
At page 86,
Yes.
paragraph 16, madam. Respondents have no specific denial of appellant's averment that Bhadra Gogoi Gohai was concubine of Prema Gohai and she was not his legally married wife. Admitted fact is that after death of Prema Gohai, present appellants instituted title suit number 17 of 2013 in this court against Bhadra Gogoi Gohai defendant and Dimbeswar Gohai pro forma defendant, and said
Bhadra Gogoi Gohai is a female.
she is a female, yes.
Okay,
Prema Gohai is the male.
okay.
And Dimbeswar Gohai pro forma defendant, and said Dimbeswar Gohai is also the pro forma defendant in title suit number 43 of 2018, renumbered as present title suit number 21 of 2022, as per order dated 28 to 2020. Appellant's case is that title suit number 17 of 2013 instituted by them against Bhadra Gogoi Gohai defendant and another pro forma defendant was disposed of on compromise between appellants and Bhadra Gogoi Gohai on 16/6/2015. Appellants have further averred that pursuant to the compromise decree in title suit number 17 of 2013, they waived, relinquished their rights, title and interest over the suit land, that is Schedule A of title suit 21 of 2022 land in favor of Bhadra Gogoi Gohai, and as such, she became the lawful owner of the disputed land. According to appellant's suit land, Schedule A in title suit 21 of 2022 and decretal land in favor of Bhadra Gogoi Gohai in title suit 17 of 2013 is the same land. Respondents have stated in their written statement as well as their written objection filing this appeal that suit land has been formally partitioned and separate patta number 769 has been issued and certified copy of Jamabandi also confirms this fact. Like title suit number 21 of 22, in title suit 17 of 2013 also, appellants had categorically contended that Bhadra Gogoi Gohain was concubine of their brother Prema Gohain, and no social marriage was solemnized between Prema Gohain and Bhadra Gogoi Gohain. Appellants asserted that Bhadra Gogoi Gohain was issueless, and respondents in their written statement have also not denied it. In their written objection filed in this appeal, respondents have specifically stated that Bhadra Gogoi Gohain was expired on 10/4/2018 and she had no issue. In their plaint in title suit number 21 of 2022, appellants have averred that defendants, respondents are brothers and nephew of Bhadra Gogoi Gohain, and as such, they have no legal character or status to claim right, title, and interest over suit land so left by her. In their written statement, respondents have not denied their contention specifically. However, respondents' plea is that Bhadra Gogoi Gohain had accepted respondents, defendant number 2, Rupang Gogoi, as her adopted son, but respondent did not adduce evidence and thereby has not proved their averment of adoption. Respondents nowhere in their written statement have denied that suit land was inherited by 3 sons of Bholanath Gohain, that is, appellants and their deceased brother Prema Gohain. Said Bhadra Gogoi Gohain in title suit number 17 of 2013 filed written statement counterclaim as wife of Prema Gohain. Appellant's brother and her prayer in her counterclaim was that she, being class 1 heir of Prema Kanta Gohain, is entitled to inherit the suit land. This court at this stage is not going to decide actual relationship between Prema Gohain and Bhadra Gogoi Gohain. What prima facie appears is that Bhadra Gogoi Gohain, due to her relationship with Prema Gohain on her claim to inherit, obtained title suit in the compromise decree in title suit number 17 of 2013. This makes no hesitation to hold that the suit land, that is Schedule A land, was inherited land of appellants and their brother Prema Gohain from their father Bholanath Gohain. Also, the suit land was inherited by Bhadra Gogoi Gohain by means of compromise decree in title suit number 17 of 2013. In their written statement, respondents have admitted that suit land was obtained by Bhadra Gogoi Gohain from appellants in connection with title suit number 17 of 2013. Now, question is upon whom the Schedule A land inherited by Bhadra Gogoi Gohain will devolve, as she was admittedly issueless. In this context, according to Section 14 of the Hindu Succession Act 1956, any property possessed by a female Hindu, whether acquired before or after the commencement of the act, shall be held by her as full owner and not as a limited owner. Such property includes both movable and immovable acquired, by the female Hindu by inheritance or device, or at a partition, or in lieu of maintenance or arrears of maintenance, or by gift from any person, whether a relative or not, before or after her marriage, or by her own skill or exertion, or by purchase, or by prescription, or in any manner, other manner whatsoever, or her Sridhana property. A female Hindu shall not be absolute owner of any property acquired by her by way of gift or under a will, or any other instrument, or the decree, order, or award which prescribe a restricted estate in such property. Section 14 of the Hindu Succession Act 1956 makes it clear that a female Hindu is absolute owner of property acquired by her unless there exists restriction on such property. The Hindu Succession Act 1956 is very specific in respect of succession of property of males and females. Section 8 of the Act prescribes general rules of succession in case of property of a male, and this section has a corresponding schedule in the Act which contains class 1 and class 2 heirs, and both the classes are in respect of a property of a male. As per the spirit of Section 8 and the corresponding sole schedule, we cannot apply its provisions in connection with property of a female. Section 15 of the Hindu Succession Act contains specific provisions for succession of property of a female Hindu. Section 50 of the Hindu Succession Act 1956 is as follows. Thereafter, my lord, the appreciation of this the statutory provision, that is Section 15 of the Hindu Succession Act. Now, your lordship will skip that, and thereafter, my lord, your lordship will kindly comes to if your lordship comes to page number 92, my lord. Page number 92, paragraph number 26, my lord. The legislative provisions and law laid down by the Honorable Guwahati High Court makes it crystal clear that the plaintiff's appellants are class 2 legal heirs of Bhadra Gogoi Gohain under Section 15 of the Hindu Succession Act 1956. That is, secondly, upon the heirs of the husband, upon whom Schedule A suit land shall devolve, and this actually is the class 2 legal heirs as averred by the appellants. Learned Munsif number 1, Sipsagar wrongly perceived and interpreted schedule of the act corresponding to Section 8 in the instant case, which confines to inheritance of property of a male Hindu. The learned Munsif number 1 erred in holding that appellants Plaintiffs appellants are not class 2 legal heirs of Bhadra Gogoi Gohai, which is contrary to specific legislative provisions as well as judicial precedents. Decision of learned Munsif number 1 in respect of issue number 3 is not sustainable, and hence interference of the first appellate court and the impugned judgment in decree is found necessary to uphold the spirit of the legislation as well as judicial precedent. It is therefore held that the appellants plaintiffs are class 2 legal heirs of Bhadra Gogoi Gohai as per the provisions of section 15 of the Hindu Succession Act. Accordingly, the issue number 3 is decided in positive.
Now
and in
what
favor of the-
substantial question of law?
Now, your lordship will kindly take up substantial question of law at page number 9. My lord, I'll rely upon the main two substantial questions of law, that is question number 3 and question number 4, my lord. And also 5. My lord. Question number 3, my lord. Whether at page number 10, if your lordship kindly sees. Question number 3, whether the learned first appellate court committed illegality and perversity in not taking the compromise decree passed in title suit number 17 of 2003 into consideration, wherein the respondents plaintiff had waived their right title and interest over Schedule A land in favor of Bhadra Gogoi Gohai, and the respondents plaintiffs were barred under section 11 of the Code of Civil Procedure 1908 to claim right title and interest over the same land in a subsequent suit. Number 4, whether the learned first appellate court committed manifest error of law and misconstrued and misinterpreted the provisions of section 15 and section 16 of the Hindu Succession Act 1956 in arriving at the findings that the respondents plaintiffs are the class 2 heirs of Bhadra Gogoi Gohai. And number 5, whether
No,
the
no,
learned
how it are? Because the plaintiffs were brothers of Bhadra Gogoi.
My lord, my respectful submission here is the very case of the plaintiff is that Bhadra Gogoi Gohai was never married to their brother. She had lived as concubine. This is their setup case in the plaint. And despite coming up with this stand in the plaint, they are claiming themselves to be the class 2 heirs of Bhadra Gogoi Gohai. It is not that they are claiming themselves to be the class 2 legal heirs of Prema Gohai. The property had already
No,
devolved.
therefore I was asking you,
My lord.
who are the plaintiffs, whether they are brothers of Bhadra Gogoi or brothers of the husband of the Bhadra Gogoi?
They are the husbands of Prema Gohai,
Okay,
who was never the husband of Bhadra Gohai. That is their case, my lord. It is not our case, it is their case. And then there is this compromise decree also, where they had waived their right, relinquished their right over the proportion of the suit land in favor of Bhadra Gogoi Gohai. And they have now subsequently filed suit for declaration of title upon the same land by way of inheritance. Now, substantial question of law, my lord, is also in respect of number 5 at page 11, whether the learned first appellate court committed perversity in holding that the decision of the learned Munsif number 1 in respect of issue number 3 is necessary to be interfered with to uphold the spirit of the legislation as well as judicial precedents. Though the legislation, that is the Hindu Succession Act 1956, nowhere refers to such spirit and neither any judicial precedent has been referred to.
Heard Mr. B. Chakravarti, learned counsel for the appellant. This regular second appeal under section 100 of the Code of Civil Procedure, 1908, has been filed by the appellants impugning the judgment and decree dated 25/4/2024, passed by learned Civil Judge Senior Division, Sipsagar in title appeal number 1/2023, whereby it reversed, it set aside the judgment of the trial court in title suit number 21/2022, which was filed by the respondent plaintiffs, and decreed the same in favor of respondent plaintiff. After having heard learned counsel for the appellant as well as after going through the memo of appeal and the documents annexed therewith, following substantial question of law is hereby formulated in this appeal. Whether the judgment of the first appellate court is perverse in not taking into account the evidence on record to the effect that there was no marriage between Bhadra Gogoi Gohain and Prema Gohain, and holding the respondents and thereafter holding thereafter coming to the finding that the respondents are class 2 heirs of Bhadra Gogoi Gohain. Number 2, whether the judgment of the first appellate court is also perverse to the effect that it failed to take into consideration the judgment in compromise decree passed in judgment and the compromise decree which was passed in title suit number 17/2003, wherein the respondents / plaintiff have waived their right, title and interest over the schedule over the suit land. Issue notice to the respondents. The appellant shall take steps for issuance of notice to the respondents by registered post with AD as well as by usual mode within 3 days from the date of this order, returnable on 18th of September 2024.
Regarding pro forma respondents, my lord, we are not, because they were party in the appeal, that's why they have been arraigned.
You issue notice to all.
My lord. My lord, there's an IA under order 41 rule 5, my lord. If your lordship takes paragraph 9 at page 10.
We'll issue notice.
My lord, why I insist on at least a status quo, because now they have been given a right of inheritance.
Mr. B. Chakravarti, learned counsel for the applicant. This application under order 41 rule 5 of the Code of Civil Procedure, 1908 has been filed by the applicants who have preferred the connected regular second appeal number 142/2024. In the appeal, this appeal is admitted. This appeal is admitted. Call for the trial court records. Who has filed the connected RSA number 142/2023. Issue notice to the respondents. The petitioner shall take steps. The applicant shall take steps for issuance of notice to the respondents by registered post with ID as well as by usual mode. The notice is returnable on 18/7. However, as in the connected regular second appeal, however, as the regular second appeal has already been admitted after framing substantial question of law in the said appeal, till returnable date, the execution on the execution of the impugn order shall remain stayed,
Deeply obliged.
list accordingly.
Highly.
I'm taking a short break.
Absolutely relevant. Obvious copies. Rakesh, আগৰ যে হেৰিটো আছিলে আগৰ কিন্তু কি আছিলে নামটো পাহৰি থাকিল
May it please your lordship. As per office note dated 26/7/2024, reminder for LCR was not issued by the registry.
LCR has not yet come.
No, your lordship. Otherwise, service is complete.
Heard Mr. S. Dutta, learned counsel for the appellant. It appears that the trial court record has not yet received by the registry. The registry to issue reminder again for the record, trial court record. List this matter after 2 weeks. List this matter after 2 weeks on receipt of the trial court records.
Much. My lord, in this case, office note shows that appellant died in the year 2011. So I have no instruction, so it already abated. So we are not pursuing this case. Though I have no instruction,
Okay,
but
when he died,
from the record, I found that in the year 2011. Sometime in the year 2011. Flex C can you see? Flex C. Yes, sir.
what will be the fate?
My lord,
What will be the fate of this appeal?
abated, nothing, it will be dismissed as abated.
No, where is the date that, where is the proof that he has, appellant has died? Flag C,
Flex C.
flag C is a application. Who is the appellant?
Nolini Das,
Who was the plaintiff also?
plaintiff also.
You are the counsel for the appellant.
I was counsel for.
Third, Mr. S.K. Ghosh, learned counsel for the appellant, who submits that the appellant had passed away on 21/3/2011. However, he has no further instructions with regard to the fate of this appeal, and whether he has any legal heirs
Yes, there are legal ones.
from the legal representatives of the appellant. Hence, by operation of law, this appeal gets abated. This appeal is accordingly closed on being abated.
And the LCR may be.
The trial court record may be sent back. The trial court, the record of title suit number 39/98 may be sent back to the trial court, as well as the record of title appeal number.
My lord, regarding title suits record, it is not traceable, so it has not come. Only appellate courts.
Okay, good. Let the record of title appeal number 25/20/2006 be sent back to the first appellate court.
Much.
Your Lordship, I'm for respondent 1 to 5.
Okay.
So representing M. Smith. We are to receive the appeal copy today.
Whether service is complete?
No, Lord, service is not complete. Okay, in respect of, there are many respondents in fact. Lordship, Mechanic Perus order dated 9/9/19, Laojima Court order dated.
Yes.
And we have paid for striking of some parties. Also there. And we are proposing to take it subsidiary service for some parties. That's why subsidiary service.
So will you be making a written application to whose name is to be strike out?
Okay, sorry. That I can,
You are Indian Oil,
yes,
make a, because who has appeared? 1 to 5 and 6, 12, these,
Column number file in respect of 6, 7, 10, 12, 16, 18, 20, 25, 32, 44, 60, 64, 69, 73, 75, 79, and 85. And service are complete in respect of 1, 2, 3, 1 to 7, 10, 12, 14, 15, 16, 7, 18, 19, 20,
you
25.
file an interlocutor application for striking out the names.
Okay, I'll file a appropriate application.
Any submission? Heard Mr. M. Gogoi, learned counsel for the appellant. Also heard Miss
Bora on behalf of M. Smith.
Miss
Bora.
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 B. Bora, learned counsel, appearing for respondent number 1 to 5, as well as Mr. U.K. Das, learned counsel, appearing for respondent number 6, 12, 16, 18, 25, 44, 60, 63, 64, 69, 75, 79 slash and 94. Learned counsel for the appellant has submitted that the appellant want to file an application for interlocutory application for striking out the names of some of the respondents. The prayer is allowed. When will you file application? How much time?
Check, we will get 3 weeks time. Because,
This is a very old,
yes, I understand. In the year 2019 itself, we have, but case was not listed.
and seeks 3 weeks times for the same. The prayer is allowed. Let this matter be listed after 3 weeks on a date to be fixed by registry.
Obliged.
My lord, I'm on behalf of my senior BK Singh, standing counsel of FCI, here for the petitioner, my lord. Order dated 29/4/2024, Honorable Court has directed the applicant to take fresh step by way of dusty method upon the respondent number 5 and 14 through the registry of court. But my lord, we came to know that respondent number 14 has expired and respondent number 5 address could not be located so far. So my lord, therefore we 6 weeks time.
Any submission?
My lord.
Heard, Miss, what is your name?
My lord, D. Pegu.
Heard, Miss D. Pegu, submitting on behalf of Mr. B.K. Singh, who
I'm appearing for 1, 2, 3, 4,
also heard,
8, 13, 17.
also heard Mr. R.K. Jain, appearing for respondent number
1, 2, 3, 4, 8, 13,
1,
17.
4,
8,
1 to 4,
8, 13,
comma,
17,
8, 13,
and 17.
and 17, 6 and 15.
No, I'm not appearing.
I'm appearing for 19, 20, 21, 20.
Also heard Mr. K. Bhattacharya, appearing for respondent number
19, 20, 21, 22, 23.
19, 20, 21, 22, 23.
All are state respondent. State of Assam.
Okay. Mr. K. Bhattacharya, learned government advocate. So, learned counsel for the applicant. For what this IA is Condonation.
My lord, in the meantime, 5 years has already gone. Even now, notice has not gone. 5 years is already.
Learned counsel for the applicant has submitted that though the applicant was directed by order dated 29/4/2024 to take steps for issuance of notice on respondent number 5 and 14 through Dusty mode. However, in the meanwhile, the applicant came to know that respondent number 14 has already expired and
Respondent number
And-
5.
and respondent number 5's correct address is not available. And therefore, the learned counsel for the applicant seeks some time to take appropriate steps in respect of respondent number 14 and also seek some time to find out correct address of respondent number 14. The prayer is allowed.
And the old matter and
Fixed date. I am giving a fixed date.
state.
The applicant shall take steps without fail within 2 weeks from the date of this order.
My lord, they may take steps within 2-3 days. And let the matter fix.
For informing this.
Yes.
My last chance, my lord, if they can't, they may be struck off, my lord. Those respondents. Now, after 5 years, if they can't,
No, whether
issue notice,
they are
then
necessary
they
or
will be
not.
Struck off, there is no other way. So
No,
there has to be some end to everything, my lord. That day I got a case, my lord, very interesting, 10 years, they have not been able to serve notice. And the case is still going on.
How much time you require?
6 weeks time is required.
That
but
means you are
my
not
lord,
sincere.
For taking steps, how 6
No.
weeks required?
There are other motives for filing this kind of cases, ma'am.
Is there any stay? No.
No.
This is,
not.
so by filing this application, the original decree has not been affected in any
Yes,
manner.
ma'am. Yes, my lord.
My lord was a judge in the lower court. I will just give an example, my lord. If such a case goes on, just some kind of high court case goes on, in the lower court, they can't execute the decree. That is the
But there
main motive.
is no bar.
There is no bar, but only filing of the appeal is no bar to execute the.
Yes,
decree
but
or
they
proceed
kind of
further.
frighten the lower judiciary.
Okay, we are giving you 2 weeks time. Let this matter be listed again on
After 15th August.
21st of August.
Agent also.
As per office note dated 31/7/2024, notice on respondent number 1 and 4 has not written answers. But today respondent number 1 has appeared. I have given copy to them also. And respondent number 4 is the owner of a Bolero car which was driven by respondent number 1. If they appeared, it will be easier for us to complete the service. Okay.
That is on him.
Okay.
You will be appearing for 4 also.
No, my lord, only for one man. We have no instructions
Then
from,
we have to take steps by Dusty on respondent number 4.
Okay.
my lord, we have some prayers to make. There is an order dated, my lord, 1/12/2021.
112.
In IA Civil 1694 of 2020.
Yes. What is the order?
My lord, the award amount has been stayed. Now the appeal in question is with regard to the 50% of the amount. The entire amount, award amount has been stayed. So this needs some kind of modification, madam.
So they have to file an application.
You have to
for
file an
modification.
application.
That may be there, my lord, but when there is apparent face on the record, I don't want to
further litigate, because Your Honor, this matter is from the lower court for 2016. Appeal was filed in 20. Now we are in 24. Secondly, my lord, when the stay has been granted, no interim amount has been directed to be paid, my lord. Apparent on the face of the record, my lord. That can be modified, my lord. No difficulty in that, my lord, because as far as the amount with regard to the Shriram Finance is concerned, they have no business to say no. Because we are unable to file an execution
Who
application.
is the appellant?
The appellant is Oriental Insurance, not
Oriental.
Shriram Finance.
Lordship will kindly see, he is not evident of fact, I think. Page 16 of the appeal memo. And claimant himself was driving a Bolero car and there is a collision between the Bolero car and a dumper. Lordship will find page 16, para 24.
That's correct.
Law is already settled, Lordship. Lordship kindly see para 24.
No. What we will do, as because you are pressing for modification of,
Malak.
you file an application.
Malak.
He will, it appears that he is not conceding.
Malak.
He will oppose your application.
Malak.
We will decide on it on merit.
Malak.
And I think Lordship may dispose this matter because it is small amount. We are challenging on the principle. And Lordship may dispose this matter if Lordship, he.
But the
still-
notices are not yet
Not
served.
respondent note 4. So we'll take a justice service on respondent note 4. If he appeared, Lordship, he was driving the Bolero car. That is why I am
Okay.
saying, Lordship.
Heard Mr. S.K. Goswami, learned counsel for the appellant. Also heard Mr. A. Sahewala, learned counsel appearing for. Mr. Sahewala, you are appearing for
For one.
respondent number 1 and
Only one.
appearing for respondent number 1.
235 has been served, Lordship. R.
It,
Goswami appeared for 5.
it appears that the notice on respondent number
2, 3, and 5 has been
2,
served.
3, and 5 has been duly served. As regards respondent number 4 is concerned, learned counsel for the appellant prays for allowing the appellant to take steps for issuance of notice on the said respondent through dusty mode. The prayer is allowed. The appellant shall take steps for issuance of notice on the respondent number 4 through dusty mode within a period of 7 days from the date of this order, returnable on which date should I fix? Returnable on
29th of August, madam.
No, we have to take steps on respondent number 4. We have to take steps and I have to file affidavit regarding justice service. It
12th
cannot be
September.
September.
12th September.
12th September. 20th September.
20th September. 20 September. List accordingly.
It was very easy if
Suitable.
we take the responsibility to take the instruction regarding.
I'll find
respondent
out
four.
if
That
I
will be
can
easy.
find out, because
You-
unless I get some
You
instruction.
cannot compel him unless he gets instruction.
Because he was driving the Bolero car.
Yeah,
And
absolutely.
that should be his own person.
I'll find out.
Obliged.
Deeply.
May Vijay Lordship. My lord, this petition has been filed, my lord. Agreed with an order passed by the executing court, my lord, in money execution case number 12 of 21, my lord. The opposite party has filed a money suit, my lord. White number.
Why it has
7
come up for orders in orders column?
Your Honor, I have filed an application praying for alteration, modification and vacation of the order dated 6/8/2022 passed by this honorable court.
6 in
6/8/2022.
in the interlocutory application.
Yes, Your Honor. I'm praying for vacation of the stay order dated 6/8/2022.
By filing the, who has filed this IA?
Your Honor, the respondent.
You are you have filed this IA.
Yes, Your Honor.
Okay. But in this okay. And where the interim order has been passed in the,
Your Honor, page 21/22, annexure A of the IA.
just a minute. $179. Where is IA 179? Oh, the CRP 179. Order dated, you tell me the date of the order.
6/8/2022.
Yes. Yes.
My lord, the petitioner has not in a position to pay the amount for which the opposite party has filed the execution petition, my lord. Therefore, the petitioner has filed an application before the concerned executing court, my lord. But the honorable court has rejected the prayer, my lord, and writ has been issued. Therefore, my lord, the petitioner come before the honorable court, my lord, for seeking some relief, my lord. Petitioner will pay. My lord, in the, during pendency of this petition, already 3 lakhs has been paid out of 4,45,686 rupees, my lord.
How much?
4 lakhs, 45,000.
45,468.60 paisa.
This is the decretal amount.
Yes,
Your
that's
Honor.
it.
Out of this, how much you have paid?
3
3
lakhs
lakhs.
has already been paid, my lord.
So 1,45,000 is outstanding.
Yes, your lordship. My lord, presently the petitioner is
And
under treatment.
You have already deposited 2 lakhs.
3 lakhs, my lord.
3 lakhs.
No,
2
Your
lakhs was
Honor, before
directed, my lord.
5/6/2022 order, the honorable court directed, they allowed them to allow their prayer for deposition of rupees 2 lakhs. And later, when this IA application was filed, Your Honor, in their objection, they have submitted that they are going to add a deposit further rupees 1 lakh.
so
total 3
including
lakhs.
this.
Yes,
so
your lord,
including
including the
this,
2 lakhs,
you have paid 3 lakhs.
total 3 lakhs have paid. My lord, therefore, may I pray, my lord, kindly allow the petitioner to pay remaining amount on installments, my lord. Because, my lord, the petitioner is serving as a SI, my lord, in APRO, my lord. He got 60, rounded about 67,000 salary, my lord. But out of that amount, my lord, 2 loan has already been taken. And now, my lord, around 25,000 he got actually after deduction of the EMIs, my lord. Out of that 25,000, my lord, he is able to pay in between 10 to 15,000, my lord, per month, my lord. Therefore, may I pray, my lord, allow the petitioner to pay
No, in
remaining
the
amount,
main civil revision application,
my lord.
in the which is the impugn order, 8/7/2022.
Annexure 10 of the civil revision petition, Your Honor.
Page number,
Page number.
Is the my lord 59.
59.
then we can dispose of the civil revision petition itself. Instead of taking IA,
Yes, Your Honor.
this can be disposed of.
Yes, Your Honor. But Your Honor, I would like to draw your kind attention how the order has been obtained, Your Honor.
No,
So-
no, because before that, let us finalize. Here, the service is complete
Yes, Your Honor.
and once you are only praying, you are not praying the judgment or decree.
No,
You
my
are
lord.
impugning the order by which your prayer for payment of decretal amount on installment was
Yes,
rejected.
yes, your lord.
Only you are challenging that.
Yes, your lordship.
And the issuance of read B state they have paid, Your Honor.
On what ground?
The prayer, Your
Only-
Honor.
Only,
Your inability to pay.
yes, Your Lordship, only
Then
that.
they will proceed. There are other avenues.
Your Honor, till now, an amount of rupees 2,08,000 something is due now. The interest accrued till July. And they are silent in their civil revision, Your Honor, regarding the payment of the remaining interest as per the decree dated 30th of June 14th. Till full realization, the amount will have to be paid.
My lord, in that regard, they can proceed in
And
their
Your
own
Honor-
course, my lord, because I am agreed, because my lord, my inability is there, my lord, and if the honorable court execute the writ, my lord, then the authority will not get anything because I have no such property to recover money, my lord. Only salary is there, my lord. And therefore, my lord,
Your humble
if your
submission,
lordship
Your
is
Honor.
to allow the petitioner to pay the remaining amount on installment, my lord, reasonable amount, then my lord, it will be justified for the petitioner, because presently the petitioner is under treatment for, my lord, acute attack, my lord. Therefore, my lord, kindly allow this petition, allowing the petitioner to pay the remaining amount on installment or deduction from the salary, my lord.
Your Honor, if their prayer is allowed,
No, not like it, not in this manner. Let me hear him first. I'll dispose of this revision petition.
Your Honor.
Otherwise, also, my lord, if I has been allowed, then this petitioner will remain nothing, my
Your
lord.
Honor, installment prayer should not be allowed, Your Honor, because they had ample of opportunity as per provisions of CPC, where they could have paid for installment even under Order 20, Rule 11(2), they could have submitted an application. Lordship, I'd like to draw your kind attention how they have obtained this order and on what grounds.
May I
The
pray one
grounds they
thing,
have
my lord?
stated that no means at one stretch they cannot pay and cannot be the genuine grounds or sufficient reasons for allowing them
Which
to
order
pay
you are
installment.
referring to? You
Your
refer to
Honor, their prayer in the civil revision, Your Honor. Your Honor, in paragraph 12 of the civil revision petition, they say that the learned trial court failed to exercise jurisdiction and power vested in it by law in not exercising jurisdiction under section 151
Where?
CPC.
Where?
Page 7, para 11 of the CRP, Your Honor.
Yes.
Para 12, Your Honor. They say that the learned trial court failed to exercise jurisdiction. So first thing, Your Honor, if there has been failure of exercising jurisdiction, then they could have approached the learned executing court by filed review petition, Your Honor, which they did not avail then and there itself, Your Honor. There also, they could have submitted a particular amount before the executing court, and the executing court could have given a reasonable stay for a few days till the review.
No, are you submitting that you don't have any objection if installment is allowed by
No, I
by
do
the
not.
executing court?
Executing court after had they allowed the warrant of attachment for movable and immovable property be executed, they didn't even wait for the Najir report, which stated that police help will be required, as he obstructed.
Okay.
25/7/2022 order, Your Lordship, annexer.
He has landed property.
Lordship, that will be that the decree holder only knows of the present property he's staying. Other property he's also having, Your Honor. Because by their petition 354/22 submitted on March 31st, 2022, they have stated only one bank account. When they submitted, Your Honor, rupees 2 lakhs, they stated another bank account. By their petition 39/2022, it was clear. Then the loan documents they have given, Your Honor, those also, there are two accounts are stated. One is SBI Guwahati University branch, and other is the Mahindra and Finance account. So that means they are having 4 accounts altogether. In this manner, they will be having other accounts also, Your Honor, and which can be well founded by the executing court, Your Honor, if they had been allowed to submit affidavit under Form 16. Your Honor, no warrant was issued. Only warrant for attachment of movable and immovable property was issued. July 22. 13th of July 2022, to which he obstructed the Nazir form of executing that particular order.
You are not conceding to his prayer for installment.
No, Your Honor, because he's a person having capable enough means to pay, and he is claiming that he is sick since 10/7, Your Honor. On 19/7/24, I have seen myself in him in the judge court premises, Your Honor. And Lordship, I would like to draw your kind attention what documents they have
Let him
submitted.
make his submissions. Apart from your prayer to
My lord,
pay on installment due to your inability to pay, what else is your submission?
my lord, at this stage, my lord, I want to pay another prayer, my lord, because the petitioner is under treatment, my lord. Matter may keep pending, my lord. During that period, my lord, the petitioner will be able to pay or not, my lord. I have to take instruction. My lord, already 3 lakhs has already been paid during pendency, my
No,
lord.
you pay remaining amount also, because there is a decree of the court.
Yes, your lordship, that is there, my lord. I am praying only under for exercising power under section 151 for considering the interest of justice, my
Okay,
lord.
okay, I'll dispose of this case.
Your Honor, 5 seconds I will take, Your Honor. I will show something to this honorable court, how the documents they have they have arranged and submitted before this court for obtaining that stay order. Your Honor, in my IS civil, page 61,
In 3431,
3431, Your Honor.
yes.
Page 61, Your Honor. It's an arrangement letter issued by the SBI, Guwahati University, Jalukbari. Your Honor, the date be seen, dated 10/1/2022.
What is this? What?
It's a personal loan application submitted by the civil revision petitioner.
Okay. Is
Your Honor, first paragraph.
how it is relevant?
It is relevant because they have claimed on basis of these 2 loans. One, this SBI personal loan, and other the Mahindra Finance.
No,
So
I'm
they
not
have-
getting you.
Your Honor, they have claimed in the civil revision petition, they are having 2 loans. As a result of that, from his salary, a particular amount is deducted
Okay.
and remains 25,000 from his salary. From
Which is
that,
why he is unable to pay your.
yes, Your Honor.
Okay.
I'd like to draw your kind attention, Your Honor. Dated 10/1/2022. And paragraph 1 of this letter, Your Honor.
Yes.
The loan is sanctioned to you as per your application dated 10/1/2022 for the purpose of personal loan. Same day the application had been given, same day the loan had been obtained.
Okay.
Then, Your Honor, second page, page 62. Guarantor not applicable.
No, no. What you want to say by showing this?
Your Honor, I submitted the execution petition on 10th of October 2022, Your Honor. Praying for realization of the entire decretal amount, 4,45,468.60 paisa. Your Honor, I submitted this on 4/10/2021.
Okay.
And this was registered as money execution case number 12/2021 on 8/11/2021. Your Honor, page 53 of my IS application, it's Annexure D series. 8/11/2021 clearly shows that the money execution case is registered on the strength of petition number 1870/21 filed by the decree holder.
Okay.
And
Now what you want to say?
Lordship, I'm drawing your kind attention, Your Lordship, fixing 10/1/2022 for tagging original case record. Your Honor, 10/1/2022 order reflects page 54 that the judgment debtor appeared without receiving any notice. By petition number 49, they had informed that executing court that from the case information system, they have come to know of the execution case, and so they have appeared. So 10/1/2022, they appeared. 10/1/2022, they applied for personal loan, obtained the loan also. Lordship, I'm bringing seriously how they are playing playing the game here in this process and showing.
No, you make clear submissions.
Yeah,
You
no.
want to submit that by taking loan.
These
They
loans,
want to show that I'm paying that
EMI for these loans.
loan, therefore I'm unable to pay.
Yes, Your Honor.
Oh,
And the same Mahindra Finance loan also, Your Honor, the first installment date was on 10/1/2022.
okay.
Your Honor, page 65. It's a offer come loan scheme acceptance letter issued by Mahindra Finance. Below it is written mode of payment. AC something next, EMI date is 10/1/2022.
Okay. Thereafter,
Thereafter, Your Honor, this decree was passed, judgment and decree was passed on 30th of June 2014.
in which
MS 783/09.
suit number?
783/09. Then after that, Your Honor, on 2014, they challenged that judgment and decree dated 30th of June
This
2014.
money he took from you as loan.
Yes, Your Honor. 1,60,000. In the money suit case, Your Honor, he denied taking loan. He also alleged that these signatures had been forged. But he failed to prove.
He preferred an appeal, no.
He preferred an appeal, Your Honor.
Appeal also.
On 28/7/2014.
By
Before the
money
civil
appeal number
judge.
5/14.
Money appeal 5/2014.
Appeal was dismissed.
Yes, Your Honor, on 15/9/2021 by the Court of Civil Judge number 2, Kamrup Metro at Guwahati. In money appeal number 5/14. Your Honor, now I filed this execution after 2 years from the date of judgment and decree, Your Honor, on 4/10/2021.
Yes.
And for this reason, Your Honor, the judgment debtor gets the ample opportunity to abstain, to take advantage of the provisions of CPC to save his skin. First, Your Honor, when the judgment and decree was passed, that passed the decree that I cannot pay so and so. If that had happened, there and that itself, he had any honest intention, then he could have submitted an application under Order 20, Rule 11, Sub-Rule 2. That too with the consent of the decree holder. Now, at what stage they had come? Where is 2014 and where is now 2022, Your Honor? Such a long gap. Had warrant been issued against him also, Your Honor, he would have given ample opportunity by the executing court. They had option of review. They had option under Order 21, Rule 1, where they could have deposited a particular amount before the executing court and could have issued a notice to the decree holder. Or he could have directly deposited or sent the amount to the decree holder and informed the court. All the opportunities that were there, they had not availed. And after, when the warrant of attachment and of movable and immovable property in the month of July was issued, and the Nazir went to execute it, then after they realized, oh, now we have to escape this loan liability. The main fact they have forgotten, Your Honor, in the civil revision, they have a silent regarding the interest that will be accumulated. They are only claiming we are ready to pay 4,45,468.60 installments. What about the remaining interest? till date. And how this order has been obtained.
In this civil division,
Yes, Your Honor.
how?
By submitting the loan documents
Okay.
which were not there during 2009, 2014, 2021, suddenly it comes up in the year 2022. Lordship, judgment is there. Bar Association, Your Honor, I'll be submitting certain judgment regarding the vacation of the stay order, Your Honor, as to how they have obtained this stay order, Your Honor. And now they are pleading that they are sick. So they type that Madhya Pradesh judgment, Your Honor, very clearly state, if you don't have any property, also the executing court will take its own course of action.
But
High Court Bar Association, Allahabad versus State of Uttar Pradesh.
no, that Madhya Pradesh.
And
Act-
certain citations are there, Your Honor, where the stay order has been obtained without allowing the court to apply the judicious might. Balance of convenience, prima facie, and irreparable injury. Prima facie, they have loan. But what about the balance of convenience? It's all tilted towards the decree holder, Your Honor. And decree holder is not being able to enjoy the fruit of it.
Okay.
Your Honor, there is one judgment. Please
want to point out
excuse me,
one thing.
submission
My
is there.
management
You
may
have
be.
to-
There is a judgment of Jammu and Kashmir High Court, Your Honor, where the same square, and not squarely covered, but same line. Without availing the provisions of CPC, they jump directly to the Honorable Jammu and Kashmir High Court by civil revision, Your Honor. Wherein certain provisions were there.
Which you have given so many judgments, which are you relying on?
Lordship, all the judgments I am relying upon, Your Honor. For the main case, civil revision also I am relying, and for the vacation of stay order also I am relying in different state, Your Honor.
We are deciding the main case.
Main case, and Your Honor, all the judgments are relevant, Your Honor. And regarding the obtaining of the stay order by misrepresenting and wrongly submitting some manipulative documents, Lordship, I'll be relying on that judgment, particularly High Court Bar Association, Allahabad versus State of Uttar Pradesh by the Honorable Supreme Court of India. Where in paragraph 15, it is clearly stated, Your Honor.
Okay. Okay. Finish your argument.
Yes, Your Honor.
You have any reply?
Only one thing, my learned friend stated that she has allowed 2 years time, but the judgment was passed in money appeal mailed on 15th of September 21, and money execution case is mailed of 21.
The main case is MS 78309, Your Honor. From that date, it will be counted, not the appeal date, Your Honor. Even in their executing court in its order has reflected on its order dated 10/1/2022 that the execution case has been filed after 2 years. The appeal is not a new case, Your Honor. The money suit main case is the main case, Your Honor. From that date, it will be counted.
Okay.
So they had several opportunities,
Now,
but they
have you
didn't avail.
finished? You have anything more to submit?
Their prayer should not be allowed, Your Honor. Otherwise, decree holder in India never gets the fruits of it, Your Honor. For this tedious execution process, Your Honor. The judgment debtors always adopt tactics to prevent it. So my humble submission.
What is your submission on the provision of Order 20, Rule 11?
Yes, Your Honor. For that, I will be relying on Seelam Ramadevi versus Gadi Raju, Yanadi Raju, Andhra Pradesh High Court judgment, Your Honor.
What it says?
Your Honor, it says. That such petition which makes prayer for installment should not be allowed because it will violate the sheer provisions of Article 126 of the Limitation Act, which says that within 30 days from the date of decree, the judgment debtor should file the application seeking prayer for installment, that to with the consent of the decree holder.
Heard Mr. M. Soikia. M. Soikia, learned counsel for the petitioner, also heard Ms. Talukdar, learned counsel for the respondent. Let this case be listed for delivery of orders on 8th of August. On 8th August, I will pass orders.
Deeply obliged.
Not of it.
Yeah, please, your lordship.
Yes,
My lord, this is a small case, my lord. I am challenging a mode of disbursements of an award, my lord. This is a cover case, my lord. I have annexed the relevant judgment also, my lord.
why it has come up in orders column?
Notice there is no private respondent, my lord.
Who is appearing for respondent? We'll take it up after rising of DB. Because at 2 I am sitting at DB, thereafter we'll take it up.
My lord, I have a small prayer, my lord, in respect of item number. 3-4 days I am suffering from fever, my lord. That matter may be taken after 1 or 2 weeks, my lord. Not changing to the present.
No objection.
But there is an interim order.
Stay order is there, my lord.
Item number 22.
Not this injunction.
Injunction.
2022. 22 on request of learned counsel for the respondent who is not well. This case is adjourned for today. List it after 1 week or 2 weeks. After 2 weeks on a date to be fixed by registry. The interim order shall continue till next day.
My lord, item 20 may be taken any other date, my lord. I have some medical emergency, my lord.
Okay. Item 20 also on request of learned counsel for the again list this matter after 2 weeks.
Oblige me.
What was the judgment?
Judgment is in the appeal, Lordship.
You were the,
I am the respondent in that case, Lordship.
the suit was dismissed.
Issue was dismissed. I filed a counter claim, Lordship, for
Oh,
divorce. He filed an application for.
your counterclaim was also dismissed.
Dismissed. That was also dismissed.
Okay. Heard,
Mr. K.K. Henry.
Mr. K.K. Hendick, learned counsel for the applicant. This interlocutory application has been filed under Section 5 of the Limitation Act 1963 for condoning the delay of 210 days in preferring the connected matrimonial appeal by the applicant/appellant. Issue notice to the respondent. The applicant shall take steps for issuance of notice to the respondent by registered post with AD, as well as by usual mode within 3 days from the date of this order, returnable on 18th of September 2024.
Deeply obliged, Lordship.
May I please, Your Lordship? Lordship, this is an application filed under Section 5 of Limitation Act, Your Lordship, for delay of condemnation, that is 80 days, Your Lordship, which is occurred in filing MSc appeal, Your Lordship, against the judgment and order dated 05/02/2024, Your Lordship.
Heard, Mr.
S.I. Akan, Your Lordship.
S.I. Akan, learned counsel for the
Claimant petition.
applicant. This interlocutory application has been filed by the applicant/claimant for condoning the delay of how many days?
80 days, Your Lordship.
80 days in filing the connected MSc appeal. Stop. Issue notice to the sole respondent. Applicant shall take steps for issuance of notice by registered post with AD, as well as by usual mode within 3 days from the date of this order, returnable on 19th of September 2024.
Deeply obliged.
List accordingly.
May it please, Your Lordship. So the IA number 2282 before Your Lordship is a delay condonation petition for condoning the delay of 264 days in preparing the revision, Lordship.
Mr. B. Halder, learned counsel for the applicant. This application under Section 5 of the Limitation Act has been filed by the applicant / petitioner for praying for condoning the delay of 264 days in preferring the connected revision petition. The issue notice to the respondents. How many respondents are there?
There are 2 respondents, Lordship.
Respondents. The applicants shall take steps for issuance of notice on the respondents, including you have to take notice on pro forma respondent also. In
So
respondent,
here in the IA, Lordship, pro forma respondent did not contest the suit. Here in the IA, I have only made parties the main respondent who have contested the suit only. Here is a suit is a between 10 urban area rain control acts. and I was the defendant in the case.
The applicant shall take steps for issuance of notice by registered post with AD as well as by usual mode within 3 days from the date of this order, returnable on 11th of September.
Actually, I have another prayer. Here in this case, the petitioner, father of the petitioner is a tenant. And a suit was proceed under India Rent Control Acts. The suit was decreed. And against that decree, the father of the petitioner prepared an appeal before the appellate court. And during that during the pendency of the appeal, the father of the petitioner died. And they put the decree into execution, and the executing court had issued summon to them to vacate the suit premises, in which the petitioner running a garage for their livelihood. So may I pray for stay of the operation of the.
Not without condoning the delay.
Because here is a judgment of our High Court in a extraordinary circumstances court can stay the proceeding.
What is the
After-
extraordinary circumstances?
Here the execution is going on, and they may anytime evict from the.
No, but
suit
you
premises.
are yourself negligent. First, your delay has to be condoned. Show
Delay
me
because
that.
the-
Show me that.
The father of the petitioner was entrusted, was taking step in this case. And after demise, the petitioner were brought on record, and after the bringing
No,
on.
how can you presume that delay would be condoned? Assuming that delay is not condoned, then your revision petition is barred by limitation. Then when the main revision petition is barred by limitation, how can you get relief in an
In the
interlocutor?
next that, since the execution is going on.
You
and they may
satisfy
evict
this
from the.
under such
May I
circumstance?
place this forever?
What is, read it,
Here in this case, is a,
whether the facts are such that without condoning delay,
here in this case, a suit was decreed against which an appeal was
No.
filed before the appellate court, and it was barred by some time. And the appellant prepared an application under Order 41 Rule 5 for staying the operation of the decree, and it was refused, again which revision prepared before this High Court. And High Court has held that in the delay is when the court will proceed with the appeal, the delay should not bar the right of the appellant. And in extraordinary circumstances, court can stay the execution proceeding.
no, what are the extraordinary circumstances? Show me that judgment.
Extraordinary, there is.
Sudeep, a judgment to the.
Paragraph 2, very short judgment. Paragraph 2 is mainly referred in this.
Mhm. No, I am not satisfied with this.
So here, in this case, the facts and circumstances almost said because it was, the judgment was passed in the appeal.
No, first
and
you have
since-
to, you bring a authority. I am fixing a short date. Returnable. When do you want?
Last part of this month.
On 30th of August.
So the execution court has fixed a date for 28 before that time. 28th of August.
On 22nd August 2024. 22nd August. And you on that day you bring any authority to show that without admitting your civil revision petition and interlocutory application in connection with that, where you are paying for interim relief, can be admitted and relief can be granted. If you satisfy, you will get relief, otherwise not. Until 28th.
May please, your lordship.
Yes.
Lordship, kindly take up IA 1600 of 2024, lordship. Here in this case, I am the appellant, lordship. Appeal is already admitted, lordship, and learned friend appear for respondent, lordship. Here I filed this IA, lordship, for minor repairing of my shop, lordship, which is situated at the suit premises, lordship. This is a Charlie.
You are the
Defendant.
decree holder, judgment debtor.
Defendant. I was the defendant.
Judgment
Yeah,
debtor.
the debtor, lordship, and
Execution is stayed.
yes, lordship, by this honor. So just minor repairing, lordship, that is a Charlie house with bamboo, lordship, post and wall, lordship, and CIC. So for some minor repairing, lordship, in my petition, I have categorically stated that I will not do any permanent construction, lordship. Paragraph 7, lordship. And this is my only source of income. That's why, lordship, my
No, but
learned friend filed one
decrease-
objection against this petition, lordship.
No objection.
Objection, lordship.
filed.
Yes, lordship, that is, lordship, kindly see paragraph, and his objection, lordship, paragraph 7, lordship. Filed on 6/6/2024, lordship. His main contention is that, lordship, I have some other source of income, lordship. But that is also I have denied in my reply, lordship.
How much time will it take? Or will we take it on Monday? Today we are already over with time. Yeah, as he is objecting, had he conceded, I would have passed.
No,
on
I have
it.
objection.
He has objections.
Because there is concurrent finding of two courts, my lord. Now this second appeal.
For eviction. For eviction.
Yes, for his eviction, I have filed a suit for declaration of my title interest. So there is concurrent finding of two courts
Yes.
below. So let it be taken on Monday.
When do you want?
Monday or Wednesday, any day. Either Monday, perhaps Monday will not listed because
Oh, yes. Wednesday.
Wednesday, that
Wednesday.
will
Heard Ms. P. Bhattacharya, learned counsel for the applicant, also heard Mr. P.
B. Bora.
B. Bora, learned
My friend
counsel
is
for
also
the
there for another respondent.
respondent, as well as Mr.
HP Gola,
H.P. Golar, appearing for respondent number 2. Due to paucity of time, this matter could not be heard today. Let it be fixed again on 7th of August 2024.
Obliged.
Hello.
তারপরে
68 or 51, 68 or 51, 67 or 58.